So good afternoon, everyone. My name is Douglas Kellner. I'm the co-chair, and call the meeting to order and introduce our fellow commissioners.
I'm Peter Kosinski.
Gregory Peterson.
Andy Spano.
I'd like to begin on the note to recall the memory of Anis Fitzgerald, who died last week or 2 weeks ago, and Anna served this board nobly for many years, and I'm sure we all mourn her passing, and I call for a moment of silence in her honor. Thank you. The first item on our agenda is approval of the minutes and the executive minutes. Is there, anyone have any changes that they want to either of those documents?
No. Their adoption.
All right, so we're adopting both the regular minutes and the executive minutes. Those in favor say aye.
Aye.
Opposed? Next item on our agenda are the unit updates. We'll start with our co-executive directors, Robert Brehm and Todd Valentine.
It's been a busy time since you were here on April 5th, and I think many of the items that you'll be voting on under new business will cover a lot of this subject matter, but filing challenge process was very busy for the entire building, and even though we have recommendations on some that are invalid for one reason or the other, that usually gets the most attention. But it was a very clean process. Most of the documents that we did receive were correct, and the group that we have for you to review under new business are really a small number compared to other times. So I think that it is a reflection. People are doing a little better job with them. One item I think we've had for too long on the agenda, I'm sure IT will cover. I don't want to take all of his thunder, but I want to at least thank Mr. Cross and his team. They finally were able to update the NICE voter conversion system. It became a little bit more complicated before Bill joined our team because in addition to upgrading the outdated equipment and software, we also were changing the entire computer system for the whole state board, and that was accomplished this weekend. That was a lot of work from a lot of people. It's a little bit behind schedule, but we are happy that we're on this side of its marking on our calendar, and now we can finish the cleanup work on that and advance some of the other items a little bit further along on that list. So as far as the unit, that was a lot of work, and I wanted to point that out. Certainly we've had a few court challenges with regard to petitions. I'm sure we'll have a few more after we make decisions today, but I think we are largely doing well to get the federal primary underway with its certification later today, based on your decisions. And the cybersecurity, the Federal Election Assistance Commission did send notice out last week that we are ready to, they're ready for states to apply for the federal Help America Vote Act money that will be used for cybersecurity. And after your review of the item in number C in new business, we can submit that on behalf of the state of New York and get the money at least put into the state's official HAFA fund, and then we can start working on implementing it. So those are like the more broad items.
No, I think that covers everything, Bob.
The next up is, we have a next call to update the county boards scheduled for Friday. We continue with our monthly calls with those, so. And we meet with the leadership. We have a call with the leadership usually 2 days before to go over what agenda items they want to cover and what issues we have to cover.
Okay, so we'll move to our councils, Brian Quayle and Kim Galvin.
Thank you, Commissioner. As the co-executive director said, it definitely has been a very busy, just a little bit more than a month since the board last met for both the compliance unit and the council unit. We have presently to report since the last meeting, there were 5 new ballot access cases. 4 of them remain pending with return dates between the 8th and 14th of this month, and 1 of them was dismissed yesterday. So we have 4 active ballot access cases presently. In other litigation matters, we were served in a new lawsuit in the Northern District, a new federal lawsuit, the Upstate Jobs Party versus the New York State Board of Elections. We prepared papers and responded to a motion for an injunction in that case, and it is returnable before the court in oral argument on Monday in Syracuse.
And the principal issue in the Upstate Jobs case is what?
The issues in the Upstate Jobs case involve treating independent bodies commensurate to, this is the relief that's being sought by the plaintiffs, treating independent bodies or a particular independent body the same way that political parties are treated with respect to hard money contributions and the ability to have a housekeeping account. And we are vigorously defending the statute. In other cases, last month we went through the entire roster. This time I'm just going to highlight significant changes in case status. In Merrill versus Sliwa, the appeal was perfected and all the papers fully briefed, and the appellate division indicated that they were going to grant a preference and hear the appeal at some point in time during the May term. I don't believe that we know the exact date, but that should come on in May, and there should be a decision very soon from the appellate division. In that case, in Brennan Center versus the New York State Board of Elections, the plaintiffs have moved for a leave of appeal in the appellate division to take that up to the Court of Appeals. In Eason, we are continuing to prepare for a trial which is presently scheduled to start at the end of May if the case does not settle. And actually, I slightly fibbed. This next one, there is absolutely no change in the status. Merced, we're continuing to await a decision on competing motions for summary judgment, and we'll see what comes there. And in, let's see, with respect to the amendments to regulations or regulations that the board advanced last month, both were duly published and comment periods remain open on both of those, the amendments to 6203 and 6215. We received 1 request for an advisory opinion, and we are researching that question. Also at the last meeting, the board indicated that with respect to a draft Bitcoin opinion, that we could send it out to various entities for comment. Nick, if you could speak to that.
Regarding
The Bitcoin, who did we send it to?
DFS.
The
Oh,
Department
that's
of
correct.
Financial
The Bar
Services.
The
Association.
DFS. We received, we solicited comments from the New York City Bar Election Law Committee, Bar Association. We solicited comment. We were asked for comments from the New York State Bar Association and DFS, and we received only a response from DFS. Essentially, their comments consisted of them correcting some of our sites and our terminology in the use of Bitcoins. However, they did not address or touch our conclusion or the analysis portion of the opinion.
So that's the
So where do we
status.
stand in terms of drafting it?
I reviewed the DFS comments, and I think they made sense, so I would suggest perhaps I could amend the opinion to
All right. And
If it's-
our,
We haven't really we've been busy with other things and they came in.
It's
so-
been a busy month.
Yeah, so we
Certainly.
could meet on that, you know, shortly and go over them. And I don't know if we want to wait for the other or reach out or
Well-
just deal with what we have and,
I think you go ahead unless, maybe I'll make a phone call to some of the people at the City Bar Election Law Committee and just say, are you gonna do anything? I don't,
okay,
they
I mean,
haven't told me they were or were not.
yeah, so we can continue to work on that.
Is DFS the,
Department of Financial
right,
Services.
are they the ultimate source of information on Bitcoins? Are they
Well,
the
they're
entity
the-
that
They
regulates
They're the-
them?
yes,
regulate them
that's correct.
within the
They're
state.
the only
Is there
state
anybody
agency.
else that regulates them, or is it just them?
They are the only state entity that has regulatory authority.
And sort of on a national basis, they're the leader. There are very few other states that have regulations.
So did you take their comments to mean that they agreed with the substance of the opinion you sent them, and they only had
I would, how I took it is that they
technical
did, right, the only comments they had were technical, and I
And
don't
you're
think
assuming
they-
from that they agreed with the
I read it
substance
that
of it?
way.
I haven't seen that. Is that how you
Well,
took it?
yeah, they,
At a minimum, they had no issue with.
I have read their comments, and I thought that since they did not address our substantive
Yeah.
proposal, I interpreted that as acquiescence to it. But they did have constructive, substantive changes, in terms of terminology, which I think we should.
That's fine.
And they've also indicated that if we had further questions, so when we discuss it, if we need to contact the gentleman that they identified in the letter, we can do that regarding the ultimate conclusion. If there's any question after a full review of it.
They were kind enough to give us a red line version of the document back. I mean, it was a very thorough analysis that they.
It really was.
Yeah, so when they redline it without touching the substantive parts of it, I would suggest that they're approving it. Or maybe the better word is acquiesce. But- Okay, I'm sorry for the interruption.
Yeah, could you just send me the
Oh, absolutely.
comments? I'd just be interested.
And with respect to the numbers of filings that the compliance unit has received, we are at a number that is, in terms of received, getting tantalizingly close to 100,000. We're at 97,801, and 88,000 of those reviews have been completed, 88,154. Of those, 15,770 in the initial review were found deficient, and 10,434 had training issues, and 61,950 were compliant. with the
Brian, what
review
period of
criteria.
time are you talking about?
That is since the inception of the unit,
Okay.
the aggregate numbers. And again, as I pointed out when we previously discussed this, that some of these numbers don't add up with the number of referrals, because just because a filing is found deficient in the initial review does not mean that it stays that way. Let's see,
So that was September of 14.
June.
June?
The compliance began before
So
enforcement.
June of 14. Okay.
and we have not referred any additional deficiencies since the last meeting. They are working on a new crop of those to be referred as we speak, and it's anticipated to happen imminently. And with respect to
So what is the number of outstanding deficiency referrals?
1,137 remain deficient.
And on non-filers, what is the outstanding number of non-filers?
I don't have the aggregate number, but for the January 2018 filing, as of the last run report, which appears to have been a few days ago, 218 of them remain outstanding. and the initial number was 2,530.
You're talking from the January.
The January 2018.
How many total filers were there in January?
I do not know. We can certainly get that information for you. We have around 14,000 active committees.
And they all have to file in January, right? That's a
Yeah.
periodic,
Yes.
everybody's got to
Yes.
file
Something.
January. So you're saying out of the 14,000 total filers, 2,500 have not filed?
Yeah,
Well,
yes,
Is that what you're saying?
2,500 did not file, but now it's down to 2,318.
yes.
Okay.
All right, anything else? Next is election operations, Tom Connolly and Brendan Lobo.
Thank you, Commissioner. With regard to elections, obviously, we had the April 24th election not too long ago. It went largely smoothly, happily. We did do election night reporting for that. We have so far received certifications from Suffolk County for the 5th and 10th Assembly District, Nassau for the 17th Assembly District, and Erie for the 142nd Assembly District. Many of the other counties who had special elections are still working on the certification process. A number of them were opening absentee ballots this week, and military ballots still have until next Monday to come back. We will prepare the documentation for the Board of Canvassers to be convened at the next meeting for certifying the 102nd and 107th. With regard to the federal primary, obviously, as was already mentioned, it has been a busy month with the filing period here. In total, we received 119 petitions for Congress, or representative in Congress, 7 nominations and 2 petitions for U.S. Senate, 72 acceptances, 63 authorizations, and 1 declination. And then we also processed 63 general objections and 19 specific objections. Staff participated both in the working of the specs and also in the hearing process. We prepared the staff report, which you will be voting on later on under ballot access rulings. And then after that, we have been working on preparing the certification for the federal primary, which is due today from the state board. And we also distributed a calendar of all relevant dates and surveys that are required under our consent decree with the Department of Justice for military and overseas citizen voters. So that's been going out, and we'll be following up with all the counties throughout the process who have a primary, so we can report that data back to the DOJ. In March, we had put out the statewide certification for offices to be filled at the general. We will be distributing an amended version of that. There was a death in the 7th Judicial District, so there will be one more justice vacancy there. And then also, the Chapter 59 of the laws of 2018 created an additional seat in the 9th through the 13th districts. So we'll be amending the certification to note those additional seats. On our voting machines, we continue to work on the certification process of the Dominion ICE machine, or the ImageCast Evolution. At this point, we're looking to move towards functional testing. Hopefully that will be done towards the end of this month, and we would be looking to have all the reports that we would need to bring to you sometime in July and or August. In addition, ES&S has also had a conference call with some of our staff about submitting their express vote machine for certification. They anticipate doing that sometime in late fall. Beyond that, we continue to work with units in the Department of Homeland Security on cybersecurity, both on a plan that you will be looking at later and also the tabletop exercises that we've spoken about at previous meetings. We have been meeting with IT about the redevelopment of the CAPAS system. We've been continuing the processing of documents related to the shoebox of funds. We have restarted our conversations with the Center for Civic Design on usability. We will be looking at a number of different topics, but we'll be focusing first and foremost on ballot design. And then what we had mentioned that we were going to be meeting, Brendan and I have met with Mark Lindeman on April 18th, who is from Columbia University, and our discussion was about an hour and a half on risk limiting audits. Brendan, did you have anything else?
That covers it.
Thank you. I was pleased to hear you hit my 2 key things to check on, which was usability and the status of audits, so thank you. So we'll turn to public information. John Conklin and Cheryl Kauser.
Thank you, Commissioner. Public Information Office was very busy since the last meeting. We've received lots of calls and emails from voters and the press about the special elections on April 24th, particularly the 102nd and 107th Assembly Districts. Questions about spec checking and the petition challenges for Congress. Questions about ballot access process for the state legislature. We've also received some questions about the governor's executive order granting pardons to some parolees, making them eligible to vote. The unit also participated in the monthly ECA call in April. We've been part of the meetings on the internal cybersecurity review and assessment on the plan that's in your packet today. The unit processed 116 FOIL requests in April. We continue to participate in at least one of the lawsuits with the council's office and IT. We assist in the planning for the cybersecurity tabletop exercises that will begin at the end of the month with the Department of Homeland Security and some of the county boards and other state and local agencies. For the website, we posted election night results for the April 24th special elections. We posted for public comment the amendments to Regulation Part 6203. The webcast and transcript for the April 5th meeting has been posted. A 2018 elections results page has been created, and most of the documents that were related to the April 24th special elections have been moved from the home page to that page. For NVRA, there was a training in Manhattan for CUNY on April 11th, which was very well attended. And lastly, the annual report is completed. You should have had copies available for you. It's not posted yet because I just want everybody to give it one last look over, so you may consider it the final draft. If you see a mistake or something that I overlooked, please let me know. We can make corrections, but it is in its final form as of right now. So I think that's everything I have. Do you have anything to add, Cheryl?
No, thank you.
Okay.
Next is information technology, William Cross.
Good afternoon, Commissioners. I start off with projects. Captus Fidus, as I've continued to report, we work on
Breathe.
Great. As I reported previously, we continue to work on filling positions for Captus Fidus. We've had difficulty. This month we had some additional progress, though. The state recently held new exams for IT titles, which now gives us a new and larger pool of candidates to canvass from. So we're taking advantage of that for at least 3 of the positions. We're also requesting additional contractor-based positions to make up the gaps that we've had not being able to fill permanent positions, but also the additional scope of the political ad legislation, which will ultimately have to take some resources from that to implement a stopgap and build those into the final system. Overall, we remain on track with the current schedule for development for Captus Fidus, and development continues on EFS, itemized, non-itemized transactions, ballot access, and data conversion. For the political ad functionality, we're taking a 2-phase approach, and we're creating a short-term solution. We've met internally to discuss what that will look like. Short-term solutions meant to meet the legislative requirements in the time frame that we have, and then ultimately build out requirements of what that will look like in the final system for full functionality of the Captus Fidus. As Bob mentioned, I'm very happy to report that the NICE voter application and databases were successfully migrated. It's been a project that's been going on predates me, but it's been one of my key focuses since I arrived, to build out a whole new infrastructure and move that system to that, get it off old hardware, old software, many of which were past end of life and now no longer supported. A lot of additional security improvements, etc. That there's still a lot of work to be done in terms of cleanup and documentation, some final site testing, but the heavy lift of it was accomplished last weekend. We also hope to move some of the other non-NICE voter components, such as our public website and some of these other pieces, over to that new infrastructure as well in the coming weeks and months to take advantage of that. At the same time, we're now focusing on readying that whole new environment we just put together to pick it up and move it to a new data center. We've been working with the Office of IT Services, State Office of IT Services, to plan that. We now have a tentative move date set for the weekend of May 19th. which at this point I think is doable. And we also continue progress on development of the in-house move application. In terms of cybersecurity, multiple efforts. IT unit continue to work with the rest of BOE on planning for the Secure Election Center implementation, which is in your packet, as well as various other security initiatives internally and for County Board of Election Systems. IT is working with other BOE areas for the DHS Homeland Security tabletop exercises planning, as well as we had applied for DHS to perform a full risk assessment of BOE systems, and we're currently developing the parameters of what that engagement looks like, what they'll be scanning, how it will be done, etc. And BOE will also be speaking on the topic of securing our elections at the New York State Local Government IT Directors Association spring conference on May 15th. In terms of the website, I think traffic to the main website has been normal, averaging a little over 200,000 page views per month, and we saw about 50,000 page views for the election night reporting related to the special election on the 24th.
So what's the current schedule for switching over to the new campaign finance reporting system?
The CAPAS schedule still remains at April 2019. Like I said, we had, huh?
I'm sorry. I just said no slippage.
No, it hasn't. We've like I said, we have difficulties with resources. We're supplementing with the contractors. We now have the political ads, which will impact it. We're trying to supplement there as well to keep it on schedule. As of today, we still remain on schedule for it.
Good. All right, next report is from Enforcement, Risa Sugarman.
The only thing I have to report, Commissioners, I have a new attorney starting today. We had a resignation, and I have a new lawyer starting today.
Who is that?
Ryan LaRose.
You're welcome, Mr. LaRose. So where do we stand now in dealing with the non-filers? So you heard Mr. Quayle indicate that the January non-filer referral was 2,318. Have you brought any proceedings against any of those non-filers?
What we've done is the numbers break down in basic. I don't have the exact numbers in front of me. There were approximately 500 A filers, approximately 1,600 C filers. The other numbers are candidates, not committees. Since the last meeting, we've broken those down to reach out to those filers. We're doing it electronically. We planned on doing it 50 each month, each week. We started with the A filers, sent out a blast email to the first 50. We got a very productive response, so what we had to postpone sending out the second blast email. As you know, that I've said before, my desire is to bring people into compliance and not to bring them compliance litigation. So we're working on bringing those people into compliance, and we'll be sending out a second notification by email. Those who don't have a functioning email, we sent letters.
So how many proceedings have you started?
I have not.
Pardon? None?
I have not.
Okay. And with respect to the older non-filers from 2016 and 2017, have any proceedings been started against them?
There have been criminal proceedings that I have worked with the district attorney's office.
And how many of those have?
I don't have those in front of me, I don't.
Obviously, none of those have been referred to district attorneys without going through the commissioners, right?
Well,
So-
the district attorney's offices have original jurisdiction. Any referrals to the AG have gone through the commissioners.
And so, am I correct that the number is less than a dozen of the
I would
roughly
say
2,000
that that's
committees
probably,
that are non-filers?
that's probably accurate.
And with respect to deficiencies, have you commenced any proceedings against the deficiencies that have been referred to you?
The hearing officer cases that have been brought, I think there are probably maybe 25 or 30, have by and large, I believe, started out with deficiencies. I don't know that to be true, but
And that's since you've started?
yes, since September of 2014.
And this,
Well, the hearing officer started, I believe were hired at the end of 2015.
and is it my understanding that there have only been 2 proceedings for hearing officers this year?
Yes, so far.
And criminal referrals this year so far?
I don't discuss referrals in public, sir.
Well, don't you have to bring them to the commissioners?
Criminal referrals are not public, Commissioner.
The number of referrals, I'm looking at my fellow commissioners.
Oh, for what purpose?
Can we disclose the number of
Oh, I don't see why,
criminal
I
referrals
think
this
so.
year?
I mean, I don't think that's confidential as far as I'm
Right,
concerned.
and,
But you're asking the enforcement council.
no, but it's the 4 commissioners that decide whether it's
Oh, I agree.
confidential or not.
I agree.
The number certainly is not.
I don't think the
All right.
number's confidential,
And
no.
am I correct that the number for this year is 1 so far?
I've given you my answer, Commissioner. I don't discuss,
The commissioners are asking you a question. Under the statute, you're required to report to the
I don't believe
commission.
that's true.
All right, so we'll move on then.
Yeah, I would just note, I was looking at your annual report, and I did note that, in context of your question earlier, that number of, I guess, judgments, you collected $4,250 last year in new judgment collections against non-filers.
That sounds right.
And you collected 67,000.
Well, I don't know that that's only non-filers. That's the number of judgments.
Okay, and then you collected 67,000 and change in old judgment.
That sounds right.
And those are from judgments that were obtained prior to your
Correct.
unit
Yes.
being created. So
Yes.
those are still coming in?
Yes. When
From-
people who have judgments against them either try to refinance
Right.
or sell their
So
homes.
there's a lien against their
Yes.
house, and you're collecting those. So just, put some context on it. So you had 4,000 new ones and 67,000 old ones. So that's sort of what's, I guess, gives some indication of the activity in that context, I think.
All right, any other questions? No. All right, so next subject is old business. I don't think there is any old business. So we'll turn to new business, and that starts with the ballot access rulings. How do you want to present that to the commissioners? I mean, is there a report that we
There
can
are-
just adopt,
There
or?
are 3 pages. It's a,
Yes,
it's
there
a
is. There's a
staff report on prima facie.
Yes, it is. We should have a
It
second.
provides in the middle a brief description of the issue, and in the right-hand column, the staff recommendation of how to treat that particular issue.
Does anyone want to be heard on the report? Mr. Bewley, is that why you're here?
No, actually, I represent the broadcaster.
Oh, okay, great. All right.
I would just move the report as presented to us by the staff as a whole.
Good.
And move its adoption.
All right, those in favor say aye.
Aye.
Opposed? All right, the report is adopted. So next are the digital ad regulations. The draft was circulated to us. We've also received public comments. Mr. Bewley, if you want to give any remarks, I mean, we've read what the New York State Broadcasters Association has submitted, which are appreciated. They're very thorough comments, and some of those issues are not incorporated in this draft yet, but at least speaking for myself, that the draft that we have today is not going to be what we ultimately adopt. It was to get something on the table so that we could start the publication process and solicit additional comments.
Yeah, I tend to agree. I mean, I think we're under a tight time frame here, and I think the idea was to meet that time frame, we needed to get something out there this month to get it in the public register so that we can start the formal process, and we'd be entertaining comments during that 60-day period when it is out for publication, and then once we get those in, we'd adopt them in a final form. Probably, I think we're shooting for maybe July. But I think we have to have them in place by August in order to meet the statute, so.
Yeah, I think August is probably more realistic.
Probably is, but I think.
And I think what will probably happen is that we'll have an emergency regulation that we adopt in August, and then we'll have to publish
Well, if we make changes,
Republish.
which we envision making changes, they'll have to go back out for another 30-day public comment. We need to adopt regulations within 120 days of it being effective, which is August 9th.
Right.
And then the technology system that Mr. Cross is working on building with the advice of our staff needs to be in place 30 days after that date. So it's an aggressive schedule, so we would look to,
Right.
and it's 30 days after your regs, so we may need closer to August 9th.
Yeah, just for clarification, we've met a lot. I think we've made great progress actually with this draft. And the more you get into it, the more you realize there's more to learn and to understand. So for those listening, if they didn't quite understand what Mr. Brem said, based upon some things that I've told people, is we have every intention of doing what we can to put this regulation in final form by approaching the final day. However, like he indicated, any substantive change will have to go back out for comment, so the emergency regulation would deem itself a placeholder while the public comment on the revised draft gets in place for final adoption. I think that's what he meant.
That's my understanding,
Okay.
too.
Not that we're just
On the
punting
advice
the
of
issue and then
counsel,
gonna
say.
pass an emergency reg, right?
Now, so both the Broadcasters Association and the News Publishers Association have sent us comments on the definition of online platform. Where does this particular draft fall with respect to their comments and suggestions?
And again, as we noted, this is an effort to put something out. What we
Right.
did is we looked at other proposals out there, including the Honest Ads Act that's proposed in Congress, in addition to proposals that are made in California and Maryland. Both the Honest Ads Act and the California acts set define online platforms as basically as entities that sell political ads and 50 million unique monthly visitors. Maryland differed from that; it was 100,000. We opted to go with the U.S. the Honest Ads Act model and the California model,
Which is 50 million.
correct.
And I think the Broadcasters
130.
Association was suggesting 130 million, right?
Correct.
I'm sorry, did you say Maryland had 100,000?
Yes.
That's correct.
So the range is from 100,000 to 135
So they're that much lower?
Million.
million.
Oh, it's 100 million.
No,
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 no.
Maryland's 100,000.
Maryland's 100,000.
The range is 100,000 to 135 million.
Well, I think there's one clarification. My recollection in Maryland, it was unique to the state, though. It wasn't visitors in the whole entirety of the country. I think ours.
How do they even
They
determine that?
can't.
No, I'm just, relaying.
That's why, but that's why their numbers have.
All right,
this
so
wrong.
our number is 50 million in this draft, and the broadcasters were proposing 130 million.
Yeah, the broadcasters indicated that 135 million would capture the top 10 sites that, according to press releases and statements by the executive, seem to be the primary focus. So we've looked at that and talked with them a little bit and indicated that we would review their comments in depth after this initial draft went out.
And Maryland, I'm reading 100 or more unique monthly U.S. visitors.
Okay, Mr. Bewley?
I mean, 100,000, I apologize.
That's okay.
But it's, yeah, but I meant to, what I meant to iterate was it's U.S. visitors.
It's
not-
US, okay,
Right.
interesting.
The broadcasters recognize the difficulty, the time frame you're working under, and we also are aware of the complexity of the issue, and we stand here to be a resource. Our proposal was largely gauged at trying to capture the larger users, and based upon our understanding of the bad actors from the 2016 election, they utilized the larger platforms because not only are they larger, but they have the ability to tailor a political ad to an individual based upon their browser user history. So if they see someone is an NRA member visiting NRA sites, or if they're a Greenpeace advocate and visiting Greenpeace sites, they can send political messages only to that person. And the veracity and efficacy of those messages are often in question.
You're saying the smaller sites can't
Well,
identify
I can tell you
people
the
that-
broadcasters don't do that. The broadcasters, just do, if they take an ad, or if they post like a commercial, let's say they have a commercial that's playing on their TV station, they put it on, they put the same exact ad. And,
Who are the biggest broadcasters in the association? How many
Disney.
hits do they get?
I don't have that number for you, Commissioner, we will. But, we have Disney, CBS. and-
So, my question would be, what's the difference between 50 million and 135 million? In other words, who would be included or excluded?
Yeah, I got that. In the memo, we have who would be included in the 1.3.
Yes, I saw that. So the question is, if we go with
I could range
50
it
million,
down.
how many other people are we including? And
Yeah, so maybe we could provide you a broader range of like, this is who's here, this is who's
Right.
getting 50 million.
well, and so the question is, where should we be drawing the line?
Well, and there's
Okay.
also the issue with the broadcast television and stations and stuff that they're FEC regulated, so it wouldn't fall under the purview of this political. They already require the
They're already
advertisements.
exempted.
Right, so
So-
some of them might not be affected unless they push that information to their online platforms, which we've talked about. So that gets into a little dicey area as well.
I will note that in our regulations, we do have a provision that states that if a broadcaster broadcasts a signal via airwaves or cable or satellite, and they also happen to stream it via their website or some application like iTunes or Slingbox or something of that nature, that would not be considered an internet, digital or internet advertisement.
Yeah, if it's the same information that's transferred,
Right.
but if their website also puts up these different types of political advertisements, they would be captured, so we have to be careful how that's done. The way I see it, and not to speak out of turn, but unfortunately, I paid a lot of attention to this particular issue.
It's fortunate.
Well,
We're happy to have.
we have, I see main issues as the definition of the platform, the number of visitors there. We also have the advertisers that, you can go to an ad agency, and some things that I've learned, and maybe the public listening would like to learn, is they can push advertisements onto these various websites into a space that they've like leased or bought, that the ultimate platform owner would not even see or know that it was showing up on their website. So there has to be a way to require the advertisement agencies that do this to fall under the same capturing requirement, because the online platform itself never doesn't control it. And we have 120 days. There's no way everybody can change every system that they do, or nor should they have to. We have that issue, we have the online platform issue, and we have, well, the IT issue and the 5-year retention requirement and what those things will look like, because that takes up a lot of space, obviously, and what exactly we're going to do there. And I think those are the main,
Get another floor in the Zen building.
problems that we see, other than what's written in the legislation itself, which a lot of this draft regulation comes out of. So it's a definite work in progress.
Well, that's great, and I'm very glad that you were able to get this draft done for this meeting, notwithstanding a very busy workload in the last month. So, does anyone have any further comments, or are we ready to vote on
I think
the
we should put it
resolution?
out and, get it out there for formal comments, and then see what else comes in besides what they've already given us.
It'll be interesting to note as well, like Facebook, I'm sure you've seen their press release, they're requiring all of the political advertisements to do attributions now.
Oh, are they?
Yeah, they've taken it upon themselves. So one of the differentiating things is this applies to IE only, it's not candidate or political committees. So it's going to be interesting to see if you see an ad and it doesn't have an attribution, who put it there? Do they fall under this? So it's another issue we're
But
going
how
to
do
work
you
through.
enforce that? How do you know that an ad out there has no attribution, whether it's an independent entity doing it versus a candidate doing it?
I have no idea.
So, I mean, how is enforcement gonna be? How would you pursue this? Would you just, well, I'm probably asking too much, but would you ask a question about, okay, we just saw this ad that doesn't have any attribution, who is it?
Maybe it's a mistake of the statute that it should require attribution.
Well, one of the requirements is that any independent expenditure committee shall obtain a copy of the registration documents that have been filed with the State Board of Elections. Now, that seems to put the onus on the particular platform. Now, what we've discussed, and you'll see in this draft, is a self-identifying line as well, so that the Independent Expenditure Committee has to say, kind of raise their hand and say, hey, I'm covered by this, and the platform says, okay, I need a copy of that, because it's not necessarily, it was, particularly in my opinion, and was agreed to, that it's not necessarily fair to have someone taking these sorts of ad to differentiate between a committee ad, an IE ad, a candidate ad, just a person out in the streets ad. So there's a lot of issues to work through, and
That's a legislative issue, right?
that's a big legislative issue, and I think that the earlier drafts may have contained more robust attribution languages in it.
So don't be bashful when you're working on the regulation. If you find a legislative gap like that, we should pass that on to the legislature.
What's the penalty for not
It's $1,000 an ad.
per ad? And that's assessed against the entity that put the ad up,
No, it's assessed against the platform,
against the platform. So the platform has the liability,
and they're
not the entity that put the ad up.
according.
There's two issues. I mean, there is the failure of attribution is one thing.
Right.
The other issue is the failure of the only issue that the platform has is they don't get the registration document from the entity and then ensure that the required attribution is there. But you would still have the issue of a potential enforcement against someone who knows they have an attribution requirement and doesn't place the attribution requirement, regardless of whether or not they placed it on an online platform. Because the attribution requirements apply to all of these kinds of ads, regardless of where they're placed. The platform issue deals with the obligation to obtain the registration documents from the Independent Expenditure Committee and to do verification.
So if I'm a platform and you come into me with an ad and say I want to put it on, do I then have to say, I need your reg form from the State Board of Elections? And I have to then see whether you are required to put up attribution, whether you're an independent entity or not?
Well,
And I have to put attribution up for you, but not for you, and I make that decision as the platform based on the registration documents the State Board has?
One of the things that we attempted to do to address that issue is because the statute places this obligation to get the registration document on the platform and also on broadcasters, separate and apart. And it requires them to get it. And we realized that when you have 79 entities out of all the entities in the world that are doing this that have that part of the requirement that apply to them, that there are some real practical issues.
You're talking about 79 independent bodies. That's
Right
what you
now,
mean by 79.
currently
Yeah.
registered here.
So there's only 79 bodies that have this
Right now.
obligation right
Right.
now.
So the draft regulation includes a provision that requires the entity, because obviously the entity knows that they are one of these things, places an affirmative obligation on the entity to provide that information to the platform or to the broadcaster, the satellite provider. But that, I think, Commissioner, that issue that you identify is one that we have to continue to think
Right.
about as we move through this process of having a workable framework that can be put in place in a way that's fair.
And one of the issues also to that point that was raised, I go and I put up an ad and I provide my registration documents, and then I come back in 3 weeks and put up 100 ads. Do I provide them again? Does my first time suffice? Does it require 100 times? Does it require 1 time? I mean, these are some of the questions that, people are asking that we have to work through.
And I think also the issue of the attribution, to the point of the confusion, is that the statute only requires the attribution relative to independent expenditure committees,
Right.
not to other committees.
Right.
They did make one significant modification. The attribution requirement used to only apply to an IE that was essentially over $1,000. And now they removed that threshold. So now every IE is required to have the attribution, but regular ads,
And
non-IE ads, are not required.
And on that point, I think it is important to note that there is still the statutory requirement that non-IE committees file their political communications with their post-election report.
Right.
And that requirement also certainly applies to these paid internet and digital ads. So there would not be that sort of in near real-time filing with us with either the weekly or the 24-hour report. But for the other committees, there would still be a filing. So after an election, in terms of trying to differentiate between whether or not an ad was from a certain type of committee or a different type of committee, there would at least be that resource.
So are we going to know who these platforms are that are going to be covered by this once this regulation is adopted? Is that our goal, is to know who they are?
Well, we hope to, although depending upon where you look, they have a different listing for, I guess there are some paid firms that people have told me that I would suggest, if it's true, we should use, that they're like the Nielsen of television. They're the online people, and that you can get an official list of who meets what criteria.
These thresholds.
Right,
Okay,
right.
so ultimately, potentially, we would know what platforms are covered by this regulation, right?
Right,
Is
but for example, you and I could be looking at the same Facebook site,
Yeah,
and your ad could be on the NRA, and my ad could be on Save the Trees, and you're the only one that ever sees yours, and I'm the only one that ever sees mine. So depending upon who sees what, who makes a complaint, who gets enforced against, I don't.
well, I guess
all
what I
those
was
varying
thinking.
issues are.
I guess what I was thinking about was if we know who the platforms are, we could send the platforms our list of independent entities and say to them, if any of these come into you and ask for an ad or want to put an ad up, you've got to give attribution.
Right, but there is no verification requirement in the statute other than that they shall obtain a copy of the form. There is no retention requirement in the statute for the platforms, other than they shall take the form. So we'd be we're working through it all.
No, I understand.
But we're, it's difficult, to sit in a room and not flip a burden that the statute requires one person to have and not the other
Sure.
person.
I'm just thinking, if I'm the platform though, and I'm ultimately going to be
Well, what we're gonna-
penalized, and you walk in my door and say, I want to put an ad up on your platform, I don't know whether you're
Well,
an
what we've
independent
agreed-
entity or not. If I had a list from the state board that
Well, what we've
that gave
agreed
them,
to
I could
do-
look down that list and say, okay,
What we've agreed
you are
to
or
do
aren't.
is post online, even though the statute doesn't require it. We've all agreed to post the 79 and the reg docs
Okay.
in a separate spot.
Okay.
So should a platform choose to double check,
Yeah.
it will be there
Because if I'm working
them.
for that platform, I want a source to go to say, this one needs attribution, this one doesn't. How do I know? I know because the state board has a list of independent entities that have to do it. Where's the list? State board has it. Let me look at the list. If you're on the list, I need an attribution. If you're not on the list, I don't.
Unless they go through an ad agency and the platform never sees it at all.
Which actually is a separate issue because, and we've discussed this in some depth, but I think it's worth calling out that we make an effort at defining an ad network in this draft because at least in the way that I tentatively look at this is that when you go to an entity and you buy an ad from that entity and then that entity separate and apart sources it out to other websites which simply provide a space to the ad network like Google Ads. In my view, it's that entity that we
agency.
regulated by the number
Right.
of unique visitors. In other words, how many impressions does their ad network generate, obviously across innumerable different domains. And that it goes back to your comment a moment ago, Commissioner, about the number of unique visitors. Because if you interpret a unique visitor to an ad network being someone who sees an ad on somebody else's website that has a feed from, say, Google Ads, metrics for that may be difficult.
Right.
So we have many interesting challenges to work through, and it is, however, coming along rather nicely, I think.
Okay.
Commissioner,
I'm confused. Join the group. I'm confused. What is the purpose of this? So you get the attribution on it,
right.
person sees it, knows this guy did it or this organization did it,
I
right?
couldn't agree with you
And
more.
they go to, now, we have all these other ads, there's no attribution on.
I
What the
agree.
hell's the sense of this legislation?
I agree.
Well, there's actually
That's
one of the.
I mean, to make it easy for everybody, if you put an attribution on everything, we don't have to go through this discussion.
Well, and actually, an attribution under this legislation is required on all of these paid internet digital ads. I call them PIDAs,
I hate that
and
word.
no one likes that. But I've said paid internet digital ad so many times in the last few weeks. Attribution is required on all of them, regardless of whether or not it's an online platform. The online platform definition in prior drafts of the legislation was more significant because in previous drafts of the legislation it required the online platform to maintain the database. But it has turned into now the only separate requirement for the online platform that is different from what applies to all of these PIDAs is obtaining the registration document from the entity. But if you are the person placing the ad and you put it on a small website that has 500, let's not get too confused here. Let's just go to 50,000 potential impressions, and it doesn't meet the definition of an online platform. It still is a paid internet digital ad if you paid more than $500 for it, and you have to have the attribution.
Only for IEs, though.
Yes.
But that's the problem, only for IEs.
Right. That's the
means that
differentiation
there may
issue.
be ads without attribution that are legal because they're paid for
Right.
by a candidate. And to me, that's a gap in the statute that we ought to recommend that the legislature fill. So that all of these digital advertisements have
It was one of the
attribution.
recommendations that we had made testimony when we appeared before the Moreland Commission, and it was in a
It was in
draft
prior
or two
drafts.
of this bill.
But
so it was
all
at
I'm
least
suggesting
considered.
is that as you work on the regs, draft the proposed statute for us to send to.
Certainly, my advice, if I was counsel to any of these people, is I would require an attribution on every political ad I put up.
And all I'm suggesting
I
is,
agree with
please
you.
write it up I can't tell you where that goes in Article 14, but you probably know. And we should just, and we should just draft the bill and review it and then send it over to the legislature.
May I just mention one thing? You said that the penalty is $1,000. It's $1,000 or up to the cost of the ad. So just, it's not,
Whichever is higher.
well, it's either $1,000 or up to the cost of the ad. That's what the statute says. So it's not just a penalty of $1,000.
Okay.
And the cost of the ad is much more significant than a $1,000 penalty.
Well, that depends too, because a lot of these ads only cost a very small amount of money.
$5 sometimes.
$5, $10, $100,
Maybe.
and they're still, well, usually.
Depends where, yeah.
Maybe, but it's misleading to just say it's a $1,000 penalty.
All right, so what's before us is Resolution 1806 to have the draft regulations posted for public comment.
I'll move to put them out.
Yeah, second.
All right, those in favor say aye.
Aye.
Opposed? All right, so the resolution is adopted. The next item on the agenda is the proposed resolution approving the cybersecurity plan pursuant to the state fiscal year 2018-2019 budget. Since this also involves the use of the federal EAC funds, it requires a commissioner vote. And we have all the documents and they've been explained. Does anyone have any questions?
Do you have anything you want
Just
Go ahead, Todd.
briefly,
to? Yeah.
so to get an understanding of what we're shooting at, you know, this is a plan, so it's still gonna involve more assistance from that, and we've developed this plan, as we said in the resolution, in consultation with both our federal partners at the Homeland Security, the Election Assistance Commission, the General Services Administration, in addition to the State Office for Information Technology, and the Governor's Cybersecurity Board, as well as meeting with the Center for Technology and Government from SUNY. And we've also sent people out to what's the Belfer Center, which is a division of Harvard that was helping us develop the tabletop exercises, which is part of our plan. But the plan really has 4 parts to it. But there's a lot of pieces to the subparts. But basically, it's assess the risks that are out there in the county, or assess the vulnerabilities in the counties, remediate those known vulnerabilities at both the state level and the county level, or provide a avenue or a way for the counties to do that. Monitor ongoing operations, because we know going forward, we have to see the traffic that comes in, the threats that change constantly. And then the third and the final piece is being able to respond to the incidents that will at some point arise. So it really boils down to build those 4 sections. One is not more important than the other. They all have to go forward kind of at the same time. So that's why, and part of it is responding to incidents is a tabletop exercise, because that's something we can do now. Department of Homeland Security is the one that developed that. We pick the sites, we've set up the regions for that, and we've tried to spread it throughout the state. We're certainly going to encourage the counties in the past and at the next call to come out to that. But it also means, you know, assessing the risks at the same time. So that's why Bill had mentioned earlier in his report about the Department of Homeland Security doing a cyber assessment of our system. So but we also know that going forward, we are not the experts in this. You know, a major portion of the plan is to, one of the first steps is to have somebody come in to help us assess where we need to go on our next steps, to develop the regulations and flesh this out going forward, because we're bringing this plan to you now to begin the spending of the money. And as Bob pointed out, one of the things we do want to do immediately is to draw down all of the federal money. And that's not because we're going to spend it right away. It's because once we have it in the state accounts, we start earning interest and we get to keep the interests. So it's in our best interest to bring it into the state accounts. And those are already set up. There's a mechanism for that. That is one of the lessons we learned in rolling out the original HAVA plan, was that there was a lot of, we needed to get help in developing, the model we're using in developing our voter registration system. We brought in some help to help us assess what we needed to do, guided us through the procurement, and then helped us with the quality assurance on the back end. Voting systems was a more challenging aspect of that because of the nature of needing to get the machines in sooner, but yet the standards were developed at the same time you're trying to do the procurement. So the difference here is that the standards are more well known, because once you take elections, the concept that it's elections out of the mix, the technology you're using it's known. It's basically the internet. It's how things are connected. Those are known items, so we have a lot of guidance on that. So I think we're still going to need help to do that. So, and what you're voting today is to begin spending both, those accounts so that we can bring people on board, start to set up a hiring plan for the long term, because as Bill points out, often it takes a long time to get technology people through the state system in place in the board, either contractors or permanent employees, and then procuring the outside services we know we can't perform, and this is all at the same time that we still have to run the June primary, the September primary, the November general election, and the counties have the same responsibility. So we're all trying to do the same thing, doing as much as we can for this year's election, and then certainly moving into 2020 to be in a better position for what we know will be a much larger election in 2020.
So let me just see if I understand what's before us here. So as I understand it, there's a pot of $24.5 million that's available for this project.
Yes.
Right, between federal and state money. So this resolution would authorize the expenditure of 6.25 of that 24.5. Is that the way I'm to read this? Is that correct? Okay.
We started with 25% of each of the funds as an estimate. So that's.
And then are we also approving? You gave us some documents with some titles and job descriptions. Are we approving the creation of these jobs, of these titles in the agency as well with this resolution? And is that all part of this, or how far along are we on that component of this? Are we like, if we approve this money, poised to go out and hire people in the titles to help us with this?
We need your authorization. Next, we would need to take those titles and bring them to civil service to classify them.
But you need our approval now to
Correct.
get those, to get that moving, and then you'd go to civil service and see if they
Because the money to pay those titles requires your vote. So I don't know if we would get civil service cooperation if we don't have the authority to spend
so you've
the money.
got a chief, let me just understand, you've got a chief information officer as a person to head. Are you creating a new unit here to do this? Are you going to put this under our current system, or is this a brand new unit that you're proposing we create within the board?
It's not a new unit. It's a combination. I think if you look, it will take some coordinated effort, but certainly from a technology point of view, it will fall under Mr. Cross, who's here. He's an existing person. He's our chief information officer.
He's right there.
We would bring in everybody identified, we would bring in as a brand new position, a chief information security officer.
Okay.
That person is more of a global policy implementer, have a requirement to make sure that the state security system is in place, but also oversee and answer questions as a source for county boards of elections who don't really have the depth of staff to be able to troubleshoot and work.
I guess my question about, before we go through each individual, my question really is, are these titles something you created? Is this something that was recommended to us by Homeland Security or somebody who's doing this? How did these titles get this designation? Did somebody say to us, these are the titles you need to do this?
These are, certainly the Chief Information Security has come to us from a lot of sources, including our conversations with the governors. task force.
Excuse me,
information.
but should we start with the fact that the governor proposed the Secure Operations Center?
That is
in his
true.
State of the State, and then has repeated it in his press releases about the budget, that
The budget language
the
requires that
Secure
we stand up a
Operations
secure
Center
center
itself is
here at the state board.
was a priority from the executive.
So what we look to do is there are points of contact, whether it be at the IT technology level. Certainly, NICE Voter and NVRA we house them in the public information unit. You know, so if you just consider that unit's title, you wouldn't necessarily from the outside think it would fit there. And we also have security related to the voting systems in election operations. So our proposal are to strengthen staff within each of those units of the agency, but with regard to the Secure Election Center, it would be the senior staff for the state board and these additional people that, depending on what the incident is, it might be technology, it might be oversight, it might be training. So we each have a different responsibility, but it won't be a separate unit that's all they do.
Okay, am I counting 8 new positions?
9.
9 new positions, okay, sorry.
I'm sorry.
No, you go ahead.
The chief information officer, is it an exempt position?
Well,
Because is his position exempt?
No.
not currently, but
What
when
does that mean? We're gonna
when
have
we've
to
talked,
position back?
well, we have to get it classified from civil service, and they're trying, they're looking at other agencies that have had similar titles or similar job descriptions. State Information Technology Services has some similar titles.
My position, it should be exempt.
I think that's what they'll come back with a
If he's in
recommendation.
charge and he's not exempt, he's gonna have an exempt position under him.
Well, this proposal is he would to be one step above, and he would move to an exempt position. And then he'd have that person under him, but we don't know the classification yet.
So I guess my follow-up is, if we create these positions, we currently have a $25 million lump sum that we can expend. But this is going to be an ongoing project, I assume. This is not a one-time, we create it, we do something, and we drop it. This is going to be a forever, so we would then increase our budget. So there'd have to be an agreement that the State Board of Elections budget is being increased by enough to cover these 9 new positions going forward as well? That's the idea
From our
here?
perspective, the $5 million state fund is a 1-year state appropriation.
Okay.
The roughly $20 million federal money is forever money, whatever that word terms is, same as other Help America Vote Act funds.
Okay.
So certainly we would need to target the 1-year money as much as possible early, because once we get to the end of the fiscal year, if we weren't able to.
But when you say it's
gone.
ongoing, Bob, it's 20 million, it's a one-time 20 million.
one
It'll
shot,
last
yeah. It'll
over
last-
more than 1
well,
year. I
it'll
get that,
last,
but it's
but-
not going to be 20 million every year
Correct.
coming our way.
But that's.
Eventually
but the
you'll run out of
$5
money.
million
Yeah.
is only one-time money. If we don't spend it, we have
I
to
get
look to
you.
the next year's
That's fair.
fiscal year budget to argue we need
Fair enough.
to repeat it.
So you want to spend the state money
This-
first?
this-
We want to spend the state money first. We've identified and had conversations with the state that they believe it's a multi-year commitment, but we still have to make that case. And I do every chance I can,
Okay.
but certainly the issue here, this plan that we're giving you tries to get us to January 2021, to get us beyond the next presidential election. We think we can cover this plan with this money until that time. If there are other resources that come in, another appropriation next fiscal year, possibly, then we'll adjust it. But I think we can support this in our plan until that period of time. We would need additional funds beyond that, because it isn't a once and it's over responsibility. This is our responsibility.
Are you gonna tell all those people when you
It's like
interview them?
getting a grant.
You're here for a year or
Starting a
two.
program, and then the grant running out 3 years from now, and having this very important program that I have to go begging for to fund.
I,
Correct.
I,
That's it.
I beat my tambourine and
Yeah.
before the legislature and the division.
Well, the
of
problem
Budget.
is, to me, it's hard to
That's it.
recruit people if you don't have any idea that you're gonna be maintained. It's hard to recruit somebody to say, you know, I've only got a one-year commitment for your job, so I want you to come to my board, I want you to start this job. I'm hiring relatively high-level people, because these are pretty high level. I want you to probably leave another high-level job to come here, but I can only guarantee you 1 year, because next year I don't know if I'm gonna have money. That's a tough way to
But we're
recruit.
talking 3 years, right?
January 2019,
Oh, 3.
2021.
You're thinking you got enough money for 3 years then to run the program between the state and federal money?
Correct.
So you could give somebody a 3-year commitment.
But it's
See
still,
someone else
still
who's
tough.
your
not-
comment is well taken.
It's still tough, because in this world, I guess people are looking, who isn't looking for longer? So I can see that's gonna be a difficult job for probably Bill, who's gonna be doing most of the hiring.
But on the
Sitting here
positive
doing-
side for the recruiting, at least the incumbent governor is
Committed to this.
committed to this program.
He's having trouble recruiting now.
I know,
Right.
that's my concern, is he's having trouble now. How much trouble are you gonna have when you are faced
I'm
with
actually
a
having, most of my
limit?
trouble is related to actual civil service types, not the exempt ones. We got a little more flexibility in terms of
I see.
hitting what we need from key skill sets going that direction.
Okay.
My main restrictions now are dealing with.
How many of these are
civil
exempt
service system.
under this plan?
We won't know until they classify them, but as many
to
as
civil
possible
service.
would be better for us.
Well, it will, because the
I think you
flexibility is important, I
think
think.
in Buffalo, we're to go there and hire a couple of those guys, bring them in, and let them try to break into all our systems, and then give us some advice. I said that facetiously, but.
That's what the FBI does and CIA.
Yeah, I don't think any plan like this is any good without some element that constantly tries to break in the system.
That is actually in the plan in terms of these risk assessments and it's all penetration testing. It is all included in there
Good.
for us in making those services available to the counties.
I don't think there's any other way to do it, just to do it with this money. We don't have much choice.
So are we ready to vote on the resolution?
Yeah, I'll make a motion to accept it.
I'll second that.
Those in favor on adopting Resolution 1807, say aye.
Aye.
Opposed? All right, so it's adopted unanimously. We have one item that is not on the agenda, which is the motion to authorize the co-executive directors to receive the 2018 Uniform State Agency Management Confidential Salary Adjustments.
Seconded.
Those in favor say aye.
Aye.
Opposed? It's adopted unanimously. And I think the last is to discuss our next meeting date.
Yeah, we have a proposal. I don't know if you guys talked about it. We were looking at June 26th, which I know is primary, but,
June 26th?
yeah, that was the date we looked at.
Where does that put us with that, Greg?
Does that work for Todd and Bob?
My understanding is it does, doesn't it?
Because it's primary date?
I mean, we're flexible that week, I think.
That's fine with me.
Where does it put us with our reg?
We wouldn't be ready by then for that, but we would need the second meeting to be, if you could schedule that one also.
August
Oh, yeah.
7th or 8th you were
Yeah, we were
talking
thinking
about?
early August, right?
It needs to be not later than the 8th.
Okay, we can do the 7th or the 8th, whichever
Yes.
you
Of
want.
what?
Of August now.
Which do you prefer?
I prefer.
I think either of those 2 days
Eighth
work
is
for
fine.
us.
Eighth is
Eighth.
fine.
Eighth,
Yeah.
eighth?
We always need every moment of the day with hearings. We just finished hearings at about 1 o'clock yesterday for today's meeting, and we didn't have as many
All right.
What happened to June
offices to deal
26th?
with.
Yeah, I think we're on, is June 26th okay, first of all?
Let me just check.
I know it's primary, and I
It's
know.
the primary day.
I know.
I didn't realize that when we talked about it earlier.
Yeah, it is.
Just kind of blocked it out.
It's just hard if we got an issue that somebody needs to talk to anybody, because we're all in this room to answer questions, but certainly if that's the day you pick, we will make it work.
Would we be better on the 27th?
We can go to 27th. Can you do the 27th? Hold on a second.
27th's okay with me.
Or is the day after worse for
Worse.
you guys?
That's a little worse, because we'll be here probably till 1 or 2 o'clock in the morning.
And everybody wants certifications and,
Yeah.
No follow-up
But
question.
not for that primary.
Oh,
It's
that's
usually
right.
who's
It's
suing
just a
us
primary.
is
Well,
by that day.
we'll still be here late, though.
Who has an impound order,
Who's in the
who has a
28th?
problem.
And the 25th, that's the Monday?
25th is good. I can do 25th.
I can do 25th.
Yeah.
That's probably better for you?
Probably the
That's
best.
better.
You want to do that?
All right, so June 25th and August 8th. And I think that could...
I would only, for those of you who have our cyber plan, there are elements in there that we would redact with regard to
Confidential, right, and security
public.
issues.
So
I'm sorry, what do you want back?
The cybersecurity
cybersecurity
plan.
has elements
Do.
that for your
Okay.
consideration, but the public version would
Okay.
have certain vulnerabilities
Don't want to
redacted.
publicize what we think.
So we will have a redacted version for
No significant
the
vulnerability.
public.
All right, so with that, is there a motion to adjourn?
Motion.
Executive session, right?
No executive session.
Make a motion to adjourn.
Those in favor say aye.
Aye.
We are.
So 20, what do we end up with?
25th.
25th and August 8th.
Yes.
Okay.
All right. I wanted.